I'm Jennifer with Anderson Coastal Group and Compass, and I'm here with our Week 6 COVID-19 update. This week, we're going to have two experts present on title and estate planning. I know that a lot of you have questions on the best way to hold title, and even if you have an estate in place, oftentimes there's little mistakes that can happen throughout the time of your ownership that might move the way that you hold title and not kind of fully execute your intended plans. So I've got Deborah and Dave here to give you their insights from their respective industries, and we hope this helps while you're sheltering in place. Thanks, and until next week.
Hi, my name is Deborah Hughes, and I'm here to talk to you today about vesting. Now, vesting is not something that a title company itself can recommend for you in one way or another. It's too personal. It's something that we would recommend that you speak to an attorney or CPA for. Now, keep in mind, too, that your vesting can change over time. As you get married or have kids, you may want to speak to your attorney again and see if you're still having the correct vesting that's best for you and your family. One of the other things we do recommend is that to make sure that your property is vested the way you think that it's vested. So here's an example. You have a property, you put it in your trust, but then you pull it out of your trust in order to do a refinance. Well, a deed needs to be recorded to put it back into your trust. And if that deed does not record, then when title looks at it, we look at the most current deed, and it would be the deed that doesn't show you in the trust. Now, that becomes an issue if we are at the point where somebody's deceased. And at that point, we might have to send you back to an attorney to work with them and resolve any issues. So please feel free to reach out if you have any questions. Thanks so much.
Hi, my name is David Pawlowski, and I'm an estate planning and estate litigation attorney with offices in San Diego and Orange County. I've been doing this for over 25 years, and this is the area that I specialize in. Deborah's asked me to take a few moments today to talk to you about estate planning and living trusts, as well as titles to properties. First and foremost, in regards to living trust, a threshold question that many people have is, should I have a trust? Do my assets qualify for me to have a trust? And a good general rule of thumb, especially in Southern California, is if you own a home, then you probably should have a trust. Having a will or not having any instrument whatsoever will end up costing you much more money in the end than setting up a living trust. And the reason for that is if you just have a will or you don't have any instrument whatsoever, when you pass away, your assets will go through what is called probate. And probate is administered by the probate courts in San Diego, which is a division of the superior courts that's responsible for administering individuals' estates when they die. Most people try to avoid the probate process by using a living trust, primarily for two reasons. First being the cost that's associated with having a probate, and secondly, the time associated with a probate. In terms of costs, attorneys are paid in a unique way when it comes to a probate. They're paid based on the gross assets of the estate, so they're not paid on an hourly basis. And what happens is that at the end of the probate, the court adds up the value of all your assets, including your home, and it's the gross value of your home. We don't deduct for mortgage purposes. And then the attorney and the executor are entitled to a certain percentage of those assets. And to give you a pretty basic example, if the only asset in the estate that's being probated is a home, say worth $750,000, the attorney would be entitled to approximately $18,000. The executor would be entitled to approximately $18,000. You'd have a couple $1,000s in costs. So you're quickly approaching close to $40,000 just in attorney's fees and executor fees and costs to probate a single asset, being a home worth $750,000. So you can see that the costs and the fees add up very quickly in a probate process. And a trust will avoid that process. The trust will also avoid a probate in terms of how long it takes to go through a probate. Normally, you're looking at somewhere between 12 to 18 months, but that can be increased depending on the characteristics of a certain case, or it can be increased, say, with something we're going through right now, like the pandemic, where the courts are closed, and probably when we're finally done with this, will be closed for, say, 3 months. So all those hearings that were scheduled to go forward have now been continued out for a number of months past that. And it's not unrealistic to think that probates right now are going to take a couple years at least. So you set up a trust, you say who you want to get the assets upon your death, you say who you want to administer the trust, be the trustee, which is like being the executor of your will, and that trust avoids having to go through that probate process. So it saves you enormous amount, or your estate an enormous amount of money, your beneficiaries and heirs an enormous amount of time. and it's just a much more efficient management tool to handle your assets upon your death. In terms of titles to property, as Deborah recommended, you want to check and make sure that the vesting of your property is properly titled. And specifically when it comes to trust, you want to make sure that that property is in your name or whoever else is the trustee of your trust name. So it's, for example, John Doe, trustee of the John Doe Trust. As Deborah mentioned, many times people do refinances and the lender requires the property be taken out of the trust during the refi process, and then for whatever reason it's never transferred back to the trust when the refinance is done. And if you pass away and that property hasn't been transferred back to your trust, the only way generally to get it back into the trust is what's called a Hegstead petition. And a Hegstead petition is a petition with the court seeking an order that based on the proof that's provided, the property should be deemed property of the trust. It's not automatic that the court grants that petition. And again, you're looking at thousands of dollars in attorney's fees and costs if it has to be done. And also, if the court denies the Hegstead petition, you end up back in a formal probate, as I described earlier, looking at possibly 2 years before that property ends up being back in the trust. So it's extremely important that you make sure that your real properties are titled in the trust, if indeed you have one. And if you don't have a trust, it's probably a very good time to seek out an experienced attorney to talk about setting up a trust. When you set up a trust, generally you want to set up a comprehensive estate plan, which would include not only the trust, but a power of attorney for finances, a power of attorney for healthcare, and also what we call a pour-over will, which is a last will and testament saying, this is what I want to happen. If one of those properties or some other asset isn't in the trust when I pass away, please pour it into the trust and follow my trust provisions. So it's like a safety document that hopefully isn't ever used, but sometimes, unfortunately, is necessary when people don't adequately check the title of their properties or the title of their bank accounts or other assets to make sure they're in their trust and are going to be properly administered by their trust. Thanks a lot. Have a great day.